Good morning, everyone. We're going to get started soon. We're still just waiting on Judge Fishman to join the call.
Thank you.
Thanks.
Sean, did you get the email I sent you?
Yes, I did. Thanks, Bob.
So it just popped up yesterday.
Okay, great.
I like to keep you informed and everything. And I actually just had a conversation with Amy Bratz here that I don't think I can make on the record because it talks about
I was going to say, Bob, I think it's recording right now, so we are on the record.
okay.
Yeah.
So it's just something I need to talk to you. That's why I didn't want to
Okay, sounds good.
talk to you off the record about things that you may have or that you may not have.
Okay, sounds good.
That you probably should. So we'll talk. I gave you a call. I was trying to get you before this, but I was without success. So,
Okay.
all right. Thank you.
We are waiting for Judge Fishman to join. If you would like, you can go off screen just while we wait, and then once he joins, we can all join back up if that works for everyone. Thanks.
Morning, Judge Fishman.
Good morning.
Is everybody else ready for to get started?
Yes.
Yes.
Then I will start the recording and we can start.
Thank you.
Okay, good morning, everyone. Today is Tuesday, September 17th, 2024. The time is 9:44 a.m. This is a pre-hearing conference in the matter of Robert Devine, case number 2024-004-S before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We're convening remotely via Zoom and this pre-hearing conference is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over the pre-hearing conference today. My name's Alex Utz, and I'm the legal fellow for the Post Commission. The matter is now before Judge Fishman.
All right. Good morning, counsel.
Good morning.
And I think I saw, and good morning, Mr. Devine as well.
Morning, Your Honor.
Sorry for the delay. Got little wires crossed on the schedule, so I apologize for that. Anyway, why don't we, let me just hear where we are vis-a-vis where we left off last time, dealing with review of discovery material, etc.
Yes,
You can bring us up to date. That'd be great.
Yes, thank you, Your Honor. When we last met, I had just received the 1 terabyte hard drive from the town, but from Stoughton, but I hadn't reviewed it at that point. I have since tried to review it, couldn't download it, contacted Amy Bratsky from the town from which it came. She was having problems downloading her own terabyte of information. She was having a consultant come in to find out how she could open it. She was unsuccessful with that. I got back to her about a week ago. A little more than a week ago, I dropped off my hard drive to her for it to be updated. In the meantime, other events have happened. So I don't have access to the terabyte hard drive. I haven't had it. I've tried to get it, and it's also happened to, I think, the other attorneys in the case. I spoke with Attorney Welsh for Matthew Farwell. He was unable to open his either, and he has returned his to the town to update it. I talked with Attorney Bratsky this morning. She tells me that she hasn't had the opportunity yet to download the information to the drive I delivered to her. So my hands are tied with the town. In the meantime, I believe we had referenced it before that the attorney for William Farwell had done a keeper of record deposition for the state police who said they didn't have records. He then did a keeper of record deposition for the Attorney General's office. The Attorney General's office was fighting that. He filed a motion to compel. That motion to compel was heard and by Judge Coltier, who wrote a decision on August 26th, releasing some of the information, but not all of the information. And I have provided Sean Martinez a copy of that.
What judge did you say issued that?
Cloutier, Cloutier.
Okay.
And the clerk's notice is dated August 27th, 2024, but her judge's memorandum of decision is dated August 26th, 2024. And I have them here. 2 days after that order was issued, I don't know if I'm sure you've heard, Matthew Farwell was arrested. Well, I'm sorry, I'm moving ahead of myself. Backing up to that order. So that order provides from August 26, 2024 by Judge Cloutier, provides that the Attorney General's office give and respond to several different aspects of the keeper of record deposition. So they're supposed to provide them. I spoke with the attorney Conley, who represents William Farwell, yesterday, and I asked him the status of these records, and he said they were supposed to be produced by yesterday, but he hadn't received them yet, and he would keep me posted. I saw nothing in the orders saying that yesterday was a deadline, but that's what he told me yesterday. So I will follow up with him. As a segue to that, as you've probably heard, Matthew Farwell has been detained for murder of Ms. Birchmore. In going through the affidavit from the special agent dated August 28, 2024, which was 2 days after Judge Cloutier's order. At paragraph 105, there is a reference to Ms. Birchmore's journals. I haven't seen the journals, and the journals document her, I guess, activity since 2013. I suspect that my client is not in those journals. And one of the allegations, I think, in this case is that my client was having relations with Ms. Birchmore while he was on the job. If Ms. Birchmore, if my client is not referenced in these journals, his absence, I think, is exculpatory. As I said, I haven't seen these journals. I don't know if they're part of the records that are supposed to be produced by the Attorney General's office or not. Also, something has come to light about some discovery after talking with Attorney Bratskier about the evidence that was provided to Mr. Martinez by the town that we have to explore, which I've talked with Attorney Martinez. I don't think it's appropriate for me to talk about the evidence given the protective orders we have in this case, but I think that's something he and I can work out. But I guess as far as the discovery is concerned, I don't have control over the terabyte. The town's supposed to give it to me. They say they're going to give it to me. I had the conversation with Attorney Bratskier actually this morning before the hearing. I actually delivered my drive to her at her house on a particular afternoon. So that's going. We haven't gotten the information from the Attorney General's office pursuant to the judge's order of August 26th. And I don't know where the journal is for Ms. Birchmore, which I believe my client's absence from would be exculpatory, as is all of the emails. My client's absence from those emails, I think, is also exculpatory, but that's to be seen because I haven't seen them all. And that's a status of discovery. I think we scheduled the dates, a pretrial and a trial date, in the anticipation that we would have all the information by now, but a lot has happened, I think, in the last month and a half, including, judge's decision came down, the arrest of Matthew Farwell, and the release of the 45-page affidavit for the motion to detention on Mr. Matthew Farwell, which is very revealing and contains a lot of information that I wouldn't be allowed to disclose based upon the current orders by the courts and Your Honor. And that's where I am. I briefly discussed this. Sorry.
Excuse me. No, go ahead.
I briefly discussed this with Mr. Martinez, and I think, and I'm not speaking for him, but I think he understands where I am as far as needing to look at the information. We did schedule, I think, the trial and the pretrial in anticipation that I would have this information, would be able to go forward, but I'm still up in the air with the discovery. And I don't think the schedule we have right now makes sense, given the information I now have that there's a journal out there. And we may not.
Did you, do I remember that you knew something about the journal being out there and anticipated that the drive you were going to get from the town was going to contain that as well?
I did. It was my understanding is there were two exhibits in the report, in the internal affairs report. There were two exhibits, and those two exhibits were complete computer dumps of Ms. Birchmore's computer. And that's what none of us got. And I think the journal would be contained, I suspect. I mean, people keep journals in their computers, I suspect, and that's probably what's in there. So that's I think where it is. I don't think anyone's seen it. And I think that if there is a journal and it's referenced in the motion for detention, and my client's not in there, I think that's a powerful piece of evidence if she's recording everything and we're not recorded.
Okay. And just to sort of make sure that the record is complete, Mr. Martinez, you haven't seen that material either, I gather.
That's correct.
Okay. And I mean, it's just odd. Obviously, this is information that's been available to the Commonwealth. I'm not talking about post-commission or the division. for some period of time now that it can't be transmitted to you and shared with you is curious, despite technical difficulties.
Right. That's why we had to get an order to compel the Attorney General's office to give us the information. And of
Right.
course, we're dealing with federal court. Federal court doesn't have to give you anything. Right? You know, they don't even give you grand jury minutes.
Right. No, I know. I faced that a lot over my career. So dealing with the federal court. Well, so as a practical matter, you really want to extend the deadlines here so that it gives you time to work out this discovery. Is that
I do.
fair
I
to
do.
say?
I think I owe that to my client.
Right. Mr. Martinez, how do you feel about that?
Yes, I think that given that at this stage there still seems to be well in the thick of discovery in the civil case, I do feel that it's appropriate. I don't think that we've gotten to the point yet where you know, the well seems to be running dry to the point that we need to you know, rush to this hearing and say we need to keep these dates no matter what. I do understand where Mr. Stowe is coming from, and at the same time that while there may be material that benefits him out there, there may also be material that benefits Post as well. And I think I do think that it would be appropriate to wait on at least some of these records. Maybe if we reach an impasse at some point in the future, we go to the hearing either way. But I think we're at the point still where discovery seems to be very active still.
Well, I agree. And as a practical matter, with the commencement of the criminal proceedings, that too may open up a large door, as it has with the affidavit and even beyond, of discovery issues and discovery materials. So I don't have the existing dates in front of me. What were they? What did we set it for?
We had a pretrial scheduled for November 14, and we had the trial scheduled for December 11.
Okay. As a practical matter, I mean, I want us to keep control over this, so we need to set another date for this. I think we should set a further status conference without setting a new hearing and trial date. That it makes sense to me. I don't want to keep changing these dates until we know we're in a position to move forward. So why don't we? We're going to cancel, Alex, the pretrial and trial dates, all right? And then let's set a further status conference. What do you think, under the circumstances, makes sense?
Well, if the Attorney General's office was to provide the information by yesterday, I suspect that Attorney Conley will be on them today trying to get that information. I do know, additionally, there's a motion circulating right now to give the attorneys in the criminal case against Matthew Farwell access to the civil documents, provided they fall under the same protective order, so that they can get access to it to help him in his criminal defense. None of the parties have objected to that motion, so I suspect that will be filed very shortly. Given that criminal case, and I know he has I think his next appearance is October 17. And I would think that the criminal attorneys are going to be trying to get that information before that date, all of the information, so they can defend him in the murder charge. So I'm just throwing that out there I suspect that the dissemination of this information should be clearly available if they're going to get in the criminal case by October 17th. So I'm just trying to throw out some.
Yeah, no, that's helpful. And as a practical matter, we all know that a criminal case is likely to get more attention anyway in terms of process, and that may end up working to our process's benefit as well. Well, what do you think about using, because it's not only getting it, you're going to need an opportunity, as you did before, to review it. Sounds like it's fairly substantial, and the division will need time to review it as well. What if we used our pretrial hearing date that we had for the next status conference for us? I think that's November 14th. Does that make sense to everybody?
Yes.
Okay. Having said that, I want to make sure nothing's changed. See, we dinosaurs still use calendar books instead of, it's like,
I need my kids to help me with my phone sometimes.
yeah, I get that. Yeah, that's so November 14th makes sense. We'll hold that date for the next status conference. Hopefully we'll be able to schedule a future dates at that time because discovery will be completed. And we'll do this if both parties are still available on that date. We'll what's the 14th? Yeah, 14th. We'll do the same thing. We'll schedule it for 9:30.
That works.
All right, and this time I'll be on time. So is there anything else you think we need to cover at this point?
I know
No,
the trial date is off, and we just get the status date on November 14th.
Right, exactly.
Thank you.
All right, thank you. Be in
Thank you.
touch. All right, bye-bye.
Thank you.
Thank you, everyone.